All right, let's jump right into it. Today we're talking about a massive ruling out of South Africa's highest court, one that has basically redrawn the map for human rights enforcement in the country. So let's break down what this actually means for everyone on the ground.
And bam, here's the bombshell right from the get-go. The Constitutional Court came out and said, flat out, that the South African Human Rights Commission, well, it can't issue legally binding orders. Just think about that for a second. That one ruling, that one sentence, changes the entire game for businesses, for landowners, for literally anyone tangled up in a human rights case.
Okay, so let's dig into the details of this thing. We're talking about a landmark legal ruling here. And get this, it wasn't a close call. This was a unanimous decision handed down on April 22nd, 2026. Every single judge on the court agreed. When that happens, you know it carries some serious weight. It's basically signaling a fundamental shift in the compliance landscape for everybody in South Africa. And this didn't just pop up overnight, no way. The court's final word here puts to bed a legal question that's been bouncing around the system for 4 long years. I mean, this case fought its way up through 3 different court levels. Talk about a legal marathon. So this ruling, it's the final definitive answer everyone's been waiting for. So you have to ask, how did we even get here? Well, like so many of these huge nation-changing legal battles, it all started with something really small, something very, very human. It all boils down to a case about a borehole, a local fight over water that somehow spiraled into a massive constitutional showdown. So picture this, it's May 2018. We're on a farm in Mpumalanga. A group of people living there file a complaint with the Human Rights Commission. Their claim? Simple. The landowner was cutting off their access to water from a borehole. The commission looked into it, sided with the occupiers, and issued a directive to restore water access. But the landowner just didn't comply. And this timeline, man, it really shows you what a slog this was. So the complaint is filed back in 2018. Then boom, 4 years later in 2022, they hit a wall. The High Court says, nope, we're not going to enforce that order. Then it goes up to the Supreme Court of Appeal and they say the exact same thing. All of that set the stage for the final winner-take-all battle at the Constitutional Court in 2026.
So why? Why did the highest court in the land make this call?
Well, it all hinges on this really crucial, kind of nerdy, but super important distinction in the constitutional powers given to 2 different watchdogs, the Human Rights Commission and the Public Protector. Okay, look closely at the wording here because this is where the entire case turns. It's all about the specific language in the Constitution. For the Public Protector, the phrase is, take remedial action. The court has already said that means their orders are binding. But for the Human Rights Commission, the language is different. Take steps to secure appropriate redress. See the difference? It's subtle, but it's everything. So what does taking steps to secure redress actually mean? Well, the court decided it means the commission is more like a referee or a mediator. Their job is to support a solution, to persuade, investigate, and engage. They're not there to bring down the hammer. It's about cooperation, not coercion. As the court itself put it, the role is to facilitate, engage, and influence rather than control and compel. Big difference. Okay, enough of the legal theory, let's get real. What does this actually mean for businesses, for compliance officers, for landowners? This is where the rubber meets the road. We're talking about the new rules of risk. So let's break it down. First, the immediate risk of being legally forced to comply with a directive is now lower. But, and this is a huge but, you can't just ignore the commission's findings. Why? Because they still carry a ton of weight as evidence if things end up in court. What this ruling really does is create this procedural gap, and it basically shifts the heavy lifting, the burden of suing, onto the commission or the original complainants. And often, those are the most vulnerable people in the dispute. So here's what the new path to enforcement looks like, and it's a lot more complicated. Before, the process could end at step 3. Now, if a recommendation is ignored, you have to go to step 4, starting a whole new lawsuit in court. It just made getting justice longer, more expensive, and a whole lot harder for everyone. And this creates a massive practical problem. The Human Rights Commission itself is basically saying, hey, we get thousands of these complaints every year. We just don't have the budget or the staff to take every single one to court. So you've got this huge capacity issue that is now front and center in the fight for human rights. So all of this really paints a picture of a pretty uncertain future, doesn't it? In this new legal landscape, who actually holds the power to enforce these rights? And maybe more importantly, what on earth happens next? Now, it's really tempting to hear all this and think, okay, so the commission is basically powerless now. But the court was super clear on this point. The SAHRC is far from toothless. It still has a ton of influence and authority. It just works a little differently now.
I mean, let's not forget what the commission can still do. They still have wide investigative authority. They can summon you for information and make you explain yourself. They can enter premises as part of an investigation, and they can subpoena witnesses. So yeah, trying to just ignore the commission's process, that is still a very, very bad idea.
In the end, the court basically tossed the ball right back to Parliament. The message was crystal clear. Look, if you want the Human Rights Commission to have the power to issue binding orders, you, the lawmakers, need to write a law that says so in plain English. The court made it obvious they weren't going to invent that power through interpretation.
Which brings us right back to the big looming question. The court has drawn a clear line in the sand, but in doing so, it has shifted this massive burden. So who's left carrying the weight now? Is it the under-resourced commission? Is it the vulnerable individuals who now have to fight their battles in court? Or is it up to the lawmakers who have been called upon to act? That, right there, is the uncertain future of human rights in South Africa.